Hello everyone, in this video we are gonna study the remaining chapters of the Contract Act, that is from the 7th subchapter to the 13th one. So let's get started with quasi-contracts, contingent contracts, termination or discharge of contracts. Okay, the first topic is what are quasi-contracts? Quasi-contracts are obligations that are imposed by law, not formed by mutual agreement like normal contracts. So here there is no offer, no acceptance, yet the law enforces duties as if they were a contract. So let's say why we need quasi-contracts. This is to prevent unjust enrichment. If someone unfairly benefits at another's expense, the law says you must compensate. Quasi-contracts are mentioned in section 68 to 72 of the Indian Contract Act. These sections cover various real-life scenarios where one party must repay or compensate another, even without a formal agreement. The next topic is contingent contract. Imagine you make a deal, but it's completely dependent on something else happening or not happening. That's a contingent contract. The law defines it as a contract to do or not to do something if some collateral event does or doesn't occur. Let's break down the essential elements. First, the event must be uncertain and in future. You can't have a contingent contract based on something that has already happened. Second one, the event must be collateral to the contract itself. It's an external condition, not the core promise of the contract. For example, let's say an agreement to sell a house is not a contingent contract. The sale itself is the main obligation. And third, a contingent contract can be dependent on the future actions of a third person. So, how does the law enforce these? Section 32 of the law is clear. A contingent contract can only be enforced if the uncertain event actually happens. If that event becomes impossible, the contract becomes void. That means it's over and you can't enforce it. Finally, there's a crucial point about agreements based on impossible events. Section 36 states that any agreement contingent on an impossible event is void from the very beginning. It doesn't matter if the parties knew it was impossible or not. For example, promising to pay someone $1,000 if two straight lines can enclose a space is a void agreement. It's based on an impossible premise from the start. So the next topic is discharge of contract. So what does it mean? It is how a contract comes to an end. So what does that mean actually? A contract is discharged when the rights and obligations of the parties are terminated. The contractual relationships comes to an end, and there are several ways this can happen. So first, we have discharge by performance. This is the most straightforward way. It happens in two ways, that is by actual performance or by attempted performance. In case of actual performance, both parties have done exactly what they promised. The job is done, the payment is made, and the contract is discharged. The second one is attempted performance. Let's say I offer to do my part of the deal, but the other person refuses to let me. The law considers my tender of performance as good as actual performance. The contract is discharged from my end. Next is discharge by agreement. This is where the parties decide to end the contract by mutual consent. And this can happen through novation, alteration, rescission, remission, and waiver. So let's see what is novation. In case of novation, we replace the old contract with a brand new one. Alteration, we change one or more of the terms of the original contract. Rescission means we simply cancel the entire contract. And remission is where I accept a lesser amount or a different type of performance than what was originally promised. And waiver is that I give up a right I have under the contract. Okay, so the third mode is discharge by lapse of time. Every contract has a time limit for its performance. If you don't perform within that time, as prescribed by something like the Limitation Act, you may lose the right to enforce it in the court. Fourth one is we have discharge by operation of law. This happens automatically due to legal circumstances like death. If a contract requires a person to use the unique skills, their death terminates the contract. Second one is insolvency. A person declared insolvent is discharged from the contractual liabilities. That is, he can't be in a contract. Third one is merger. When a lesser right merges with a greater right, the lesser one is discharged. Our fifth mode is discharge by impossibility of performance. If an act becomes impossible to perform after the contract is made, the contract is discharged. For example, if you contract to sell a specific car, but the car is destroyed in an accident, the contract is discharged due to impossibility. And finally, the sixth mode, we have discharge by breach. This is when one party fails to perform their side of the bargain. A breach puts to an end to the contract and the innocent party can sue for the damages. So, those are the primary ways a contract can be discharged. So, we talked about how contracts are made and how they can be discharged. But what the correct way to end a contract when one party is not cooperating? So, now we are going to focus on the proper termination of a contract. So, in the eyes of the law, you can't just walk away from a contract. There's a proper procedure to follow. The most common and legally sound way to terminate an agreement is by issuing a formal notice to the other party. This notice serves a very clear purpose. It gives the other party a final reasonable deadline to complete their side of the transaction. The notice explicitly states that if they fail to perform their obligations within this definite time, the contract will be considered cancelled. So the next subchapter is assignment of contractual rights and obligation. So assignment is a transfer of a contractual right or liability from one party, that is the assigner, to the another party, that is the assignee, who is a stranger to the original contract. So it simplifies and speeds up the commercial transaction. For example, if A owes B rupees 500 and B owes C a similar amount, B can assign his right to receive payment from A directly to C. So if A accepts, this becomes an assignment of B's right to C. So next one is dispensing with performance, that is section 37. So section 37 of the Indian Contract Act 1872 allows party to an agreement to dispense with the performance of a person. This means they can mutually agree to not perform their respective promises, and this is considered a valid excuse for non-performance. So this also applies in cases where the performance of a promise is excused or dispensed with under the provisions of the Act or any other law. Next one is death of a promiser. The promises of a deceased person bind their representatives unless a contrary intention is specified in the contract. Okay, so the next topic is refusal to accept offer of performance, and that comes under section 38. So it states that if a promiser makes an offer of performance but the promisee refuses to accept it, the promiser is not responsible for non-performance. So let's see what are the conditions for a valid offer. So it must be unconditional, proper time and place, reasonable opportunity to inspect. So in case of unconditional, the offer must not be subject to any conditions. Proper time and place means it must be made at the proper time and place and under circumstances with the person to whom it is made has a reasonable opportunity to ascertain that the promiser is able and willing to perform. And the third one is reasonable opportunity to inspect. If the offer is to deliver something, the promisee must have a reasonable opportunity to see that the thing offered is what the promiser is bound to deliver. The next subchapter is representations and warranties. So, first let's see what are warranties. So, these are promises of indemnity. While the Indian Contract Act 1872 does not define warranty, it states that if warranty is breached, it leads to indemnification. So, first let's see what is contract of indemnity under section 124. So, contract of indemnity is one where one party promises to save the other from a loss caused to them by the conduct of the promiser or any other person. It's essentially a contract of indemnity. So now let's see the rights of indemnity holder, and that comes under section 125. When sued, the person who has been promised indemnity is entitled to recover the following from the promises. He can get all damages they are compelled to pay in any suit, all costs for bringing or defending a suit, and all sums paid under the terms of a compromise as long as it wasn't contrary to the promiser's order. Okay, so the next topic is misrepresentation. Although not defined in the Act, misrepresentation is defined in section 18 and it includes a positive but unwarranted assertion of something that is not true even though the person makes it believes it to be true, and any breach of duty that gives an advantage to the person committing it without an intent to deceive and prejudices another person, and causing innocently a party to an agreement to make a mistake as to substance of the thing that is the subject of the agreement. And now let's see the effect of misrepresentation, and it comes under section 19. So when consent to an agreement is caused by misrepresentation, the agreement is voidable at the option of the party whose consent was so caused. So exemption to this, and an agreement is not voidable if the party whose consent was caused by the misrepresentation had the means of discovering the truth with ordinary diligence. This exception does not apply if the misrepresentation was fraudulent or through silence with the meaning of section 17. So the next subtopic or subchapter is impossibility and force majeure. So contingent contracts, that is enforcement and impossibility, and it comes under section 32. So a contingent contract can only be enforced if the future uncertain event on which it depends happens. So if the event becomes impossible, the contract becomes void. For example, a contract to buy B's horse. If C dies before A cannot be enforced unless C dies before A. The next topic is contingent on impossible event, and it comes under section 36. An agreement to do or not to do something contingent on an impossible event is void from the start, regardless of whether the parties knew the event was impossible. An agreement to perform an impossible act is void in itself. Force majeure clause. A force majeure clause is a contractual provision that excuses parties from performing their obligations due to circumstances beyond their control. So this includes events like pandemics like COVID-19 lockdowns that make performance impossible or unlawful. And the term force majeure is not explicitly defined in the Indian Contract Act, but such clauses are generally upheld as they address supervening impossibility. And it comes under section 56 of the Indian Contract Act. A force majeure event that leads to impossibility or illegality of performance makes the contract void.